So I have an update for the current assault weapon ban challenge that is up for Supreme Court review. The government here is now trying to delay Supreme Court review of this critical issue. So let's talk about what is happening. Now, really quick before we jump into this video, I want to mention once again that we now have a second channel available. I will have links down below in the detailed section in the pinned comment. Over there, we're going to be covering some other, legal issues, some broader topics, some more mainstream topics. So if you're interested in that, check that out. Subscribe over there. And then also just double check to make sure you're still subscribed over here because YouTube loves to unsubscribe people. Now, as I mentioned in the intro, in this video, we are going to be talking about how the assault weapon ban case, which is currently seeking Supreme Court review, is potentially going to be delayed once again because the state here, the government here, does not want the Supreme Court to address this issue this year. In this video, we're going to be talking about the Maryland assault weapon ban challenge known as Bianchi versus Brown, or now Snope versus Brown. The Fourth Circuit en banc panel stuck to their position that semi-automatic rifles like AR-15s are useful in military service, that they're militaristic weapons, and because of that, the state can regulate them however they want because they claim they are dangerous and unusual, and they are not arms protected by the text of the Second Amendment. Now, although that was an immediate loss, that decision was still a merits decision, which I think is going to lead to a long-term win because this case is now in front of the Supreme Court seeking Supreme Court review. But as always, the anti-gunners are trying to stall and delay these cases, and for a second time, the state here is requesting that they get even more time and delay this case at least until probably next year. Now, for those not aware, this case involves the state of Maryland defining certain firearms as so-called assault weapons, and therefore they banned them in the state. This ban was challenged in the state of Maryland in a federal district court. However, this case was then dismissed by that lower court because there was already a case that was on the books that found that this Maryland ban did not violate the Second Amendment. And that prior case was known as Colby. And in that case, the Fourth Circuit en banc panel had already ruled that the Maryland ban did not violate the Second Amendment. Now, this case, Bianchi/Snope, conceded that Colby was the controlling precedent, but they argued that that decision was incorrect and should be reversed. Now, after that dismissal at the federal court level, at the district court level, they then appealed up to the Fourth Circuit. The Fourth Circuit once again upheld the dismissal, and that led this case, Snope, for the first time to make its way to the Supreme Court back in 2022. The Supreme Court ultimately held this case, but then ruled in a different case, the landmark case Bruin. And then after that, they decided to GVR, grant, vacate, and remand this Bianchi case, the Snope case, back down to the Fourth Circuit for a new decision in light of Bruin. This case then was opened back up at the Fourth Circuit level for a new decision in light of Bruin. And then oral arguments were held in front of a 3-judge panel in the Fourth Circuit back in December of 2022. But then the case sat pretty much dormant and silent for 13 months. Suddenly, out of nowhere, then all of a sudden, the Fourth Circuit en banc panel decided that they wanted to take review of this case. They took it out of the hands of that 3-judge panel that already heard arguments in this case, and they said that they were going to rule on it on their own, and they did that because they wanted to avoid any pro-Tway decision. The Fourth Circuit en banc panel issued their decision essentially upholding the rifle ban here in Maryland, finding that it was constitutional, and in that decision, the majority stated that the assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Now, there was a dissent in the Fourth Circuit. You had judges like Judge Richardson, who was joined by Niemeyer, Aggie, Quattlebaum, and Rushing, and they essentially called out their colleagues. They said that they were doing this for a very clear reason. They were not respecting the Second Amendment. They were defying the Supreme Court in Bruin, and this was an incorrect decision. They stated in that dissent that the majority decides that Maryland's ban is perfectly consistent with the Second Amendment, but the majority's rationale disregards the Second Amendment and controlling precedent. Rather than considering the amendment's plain text, the majority sidesteps it altogether and concocts a threshold inquiry divorced from the right's historic scope. Now, after that Fourth Circuit en banc panel decision, there was then a clear path to go back to the Supreme Court with this case on a merits basis, which is what the Supreme Court has been asking for a long time. The plaintiffs have now submitted to the Supreme Court for their review, and originally, Maryland was set to respond to this petition on September 23rd. But as we've talked about in a prior video, the state had originally asked for an extension of time for 30 days. Now, in that original letter for the extension or the delay, they first stated that the extension is necessary because of the press of other assigned work. Notably, undersigned counsel and others associated with this case are involved in matters relating to the collapse of the Francis Scott Key Bridge in Baltimore, as well as other ongoing Second Amendment litigation. The requested extension is necessary to ensure that undersigned counsel and others can devote sufficient attention to those proceedings as well as the response to the petition here in this court. Counsel for petitioners have consented to this request. So the Maryland Attorney General argued that they are dealing with some other issues related to the bridge collapse, the bridge issue there in Baltimore, and some other two-way cases, and therefore they needed a 30-day extension, a delay on their response. And the plaintiffs there originally in that first request did not contest it. They said, okay, we'll give you 30 days, we'll concede to that. And that happens a lot of times. You have the government or the other, opposing side, the attorneys will say, okay, we agree to a 30-day extension for you to file your papers. But now what is happening here in this case is the state of Maryland and the Attorney General's office is now asking for a second extension, even more time. And now it's clear that this has nothing to do with other than the state here actually wanting to delay this case and potentially push it out at least until next year. The state is now asking for a second 30-day extension. And in their new request, they're simply using the same excuse that they're having to deal with other legal cases. They're having to deal with the Baltimore Bridge lawsuits and cases. And nothing new has popped up, no other additional reason. They're just simply using the same copy and paste for the second time, asking for a new 30-day extension. But here you have the plaintiffs saying, no, they don't agree to that. And actually, they're pushing back against that because the reason for that is if this was granted, that would then push the state's here response out at least until November 22nd. So they would not even have to respond until November 22nd. And that would also mean that the Supreme Court would likely not hold conference on this case in this issue until probably next year. So this case wouldn't even be first presented and reviewed by the Supreme Court until next year, which is a big problem because we want this addressed as soon as possible. The plaintiffs in this case have responded to that second delay request by opposing it, and they're asking for the Supreme Court to deny that extension. They state in their letter that in recognition of the importance of this case and desiring an opportunity to present this issue to the court this term, we filed the petition for a writ of certiorari just 15 days after the Fourth Circuit issued their decision below. As the deadlines in this case currently stand, and after the respondents already received an initial 30-day extension to which we did not object, this case will be distributed on November 6th, 2024, and will be considered by the Supreme Court for its first time at the November 22nd, 2024 conference. With just 3 conferences remaining before the end of this year, a 30-day extension would mean that this court would not consider this case at conference until January 10th, 2025. If the court is inclined to grant any extension at all, it should not delay this case more than 13 days to permit this case to be distributed on November 19th, 2024 for consideration at the December 6th, 2024 conference. So here you have the plaintiffs saying this is clearly a delay and a stall tactic by the state of Maryland. They're trying to push this out until next year, but here the plaintiffs want this to be in conference this year, before the end of this year, so that the Supreme Court could ultimately decide if they want to grant review to this case this term. So this is important because this will determine how fast the assault weapon ban challenge will potentially be up for Supreme Court consideration. Clearly, the state is engaging in a delay tactic, so hopefully the Supreme Court agrees with that. And at the very least, if they're going to grant any more time, it's only the limited amount of time that the plaintiffs are asking for, the 13 days. And then, that would mean that this case can go to conference before the end of this year. So that's what's currently happening in this critical case that is seeking Supreme Court review of the issues of statewide bans on so-called assault weapons. We're going to be watching this closely to see what happens. If anything else changes, if we get any more information, I will let you guys know. Also, if you like this video and you would like to support this channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.